he's been ready for quite a while. Okay, let me get my pages all turned to the right stuff. And then we'll get ready to go. All right, I am ready.
Me too.
Okay, so now got it. Okay, so now it's being recorded live. So we will proceed in cause 2022 0D0 2032. State of Texas versus Jesus Miguel Chacon, present in court with his attorney, Mr. Robert Harris. And for the state, I believe it is Mr. Ray Duke. And are the parties ready to proceed?
Ray Duke for the state, Your Honor. State's ready.
Robert Harris, we are ready, Your Honor.
All right. Now, is your true and correct name Jesus Miguel Chacon?
Yes, sir.
Your date of birth, 4/13 of 2004?
Yes, sir.
And you recognize your attorney, Mr. Harris?
Yes, sir.
And Mr. Harris, you recognize your client, Mr. Chacon?
I do.
Okay. Now, Mr. Duke, I believe this is a plea agreement. So if you would like to state the plea agreement on the record.
Your Honor, exchange for the defendant's plea of guilty to the deadly conduct of a discharge of a firearm, which is a third-degree felony. The state of Texas is recommending 2 years TDCJ with credit for all time served.
So it's going to be, the plea is to deadly conduct, discharge firearm. That is the plea.
Yes, sir.
Got it. Okay. And that is a third-degree felony. And is that your understanding of the plea agreement, Mr. Harris? You're on mute, though.
Absolutely, yes. That's the agreement.
Okay. And Mr. Chacon, is that your understanding of the plea agreement?
Yes, sir.
Okay. Now understand that the plea agreement is not absolutely binding upon me, but should I choose not to follow it? Should I choose to be harsher than that? Should I choose to be harsher than that, you could withdraw your plea and we could proceed to a trial on this matter at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your plea. You cannot appeal the case without my consent. You would be transferred to the Texas Department of Corrections at their earliest convenience to serve out whatever remains of this sentence. You understand that?
Yes, sir.
Okay. Now, we have in front of us some documents marked State's Exhibit 1. The guilty plea and waiver forms in this case, they bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you, in fact, sign these documents?
Yes, sir.
Did you read them before you signed them?
Yes, sir.
Did you understand what you were reading and signing?
Yes, sir.
Did your attorney further explain to you the meaning of those documents?
Yes, sir.
Do you have any question about their meaning?
No, sir.
So if there's never any question, let me briefly explain to you what they mean. Primarily two things. You're coming into court telling me through a judicial confession, yes, Judge, I did commit this offense, or I was involved in the commission of this offense as a party under the laws of the state of Texas. And secondly, you're telling me that you understand you're giving up some valuable rights here today. The most important of those rights is your right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Yes, sir.
Understanding that, how do you plead then to this charge, guilty or not guilty?
Guilty.
Entering your plea of guilty freely and voluntarily?
Yes, sir.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, sir.
Did anybody promise you anything or persuade you in such a manner that you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, sir.
Now, you understand this is a felony of the third degree, punishable by not less than 2 years, nor more than 10 years in prison. A
Yes,
fine
sir.
not to exceed $10,000. Now, I think would he have been eligible for probation on this charge?
Yes.
Okay,
Not
so,
a,
okay, now you understand that if you had gone to a jury could have given you probation. Of course, they could have given you more time too. And so you understand by doing this, you give up the right for any opportunity to seek probation from a jury.
Yes, sir.
Okay, and you understand that.
Yes, sir.
All right. Now, so that's the potential punishment range, and you understand the potential punishment range, correct?
Yes, sir.
Now, are you a U.S. citizen?
Yes, sir.
And how old are you?
18.
And how far did you go in school?
I graduate.
High school graduate.
Yeah.
And so you can certainly read and write the English language.
Yes, sir.
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
Yes, sir.
What kind of issues?
Um, uh, I can't remember, sir.
Okay. Are you presently under medications?
Yes, sir.
What kind of medication?
Prozac and Remox.
Okay. And they're to help you with what?
With anxiety and sleep.
So you have some anxiety and sleep disorders.
Yeah. Yes, sir.
Okay. Are these medications helping you?
Yes, sir.
Are they helping you to such a degree that you feel that you are mentally competent? You understand everything that's going on here this afternoon.
Yes, sir.
Now, you also understand that by pleading guilty here today, you cannot appeal this case and you cannot withdraw your plea without my consent. You understand?
Yes, sir.
So it'll become final in not too long. Okay, Mr. Harris, you've had time to go over the facts and circumstances of this case, the legal aspects of the case, and had time to evaluate your client's mental status. You're on mute again. I'm sorry, Mr. Harris, you're on mute. We can't hear you. Yeah, I'm sorry, you're still on mute.
Okay, Judge,
Yes,
this system has been going on and off, on and off, on and off, on and off. It says you're on mute and then it's been a mess, but I've been following. And yes, he is competent.
okay, you've had plenty of time to determine that you believe he is
Oh,
mentally competent, as that term is
I've met him,
defined under Texas.
many times. I've met him many times in jail. He's competent.
Okay. All right. Then, based on your representation, Mr. Harris, your representation, Mr. Chacon, the court's observations of you in court, both here today and prior occasions, I find that you are competent to enter the plea. The state may summarize the evidence.
Judge, we lost Mr. Harris.
Okay. Well, we got to wait then till we get him back.
I think he's back.
There. Okay.
Mr. Harris, if you can just put your camera, turn off your camera. I think that'll help you with the Wi-Fi issue, and then just leave your microphone on.
Okay, it says
There you
Zoom,
go.
man.
Yes,
Sure.
just leave it like
There.
that. That's fine.
Okay. It's working. Okay.
All
So
right.
now, Mr. Duke, you may summarize the evidence.
Thank you, Your Honor. Had the state of Texas proceeded to trial, the state of Texas would have proven beyond a reasonable doubt that on or about the 26th day of April 2022, in the county of El Paso and state of Texas, Jesus Miguel Chacon did then and there knowingly discharge a firearm at or in the direction of a habitation, and the defendant was reckless as to whether the habitation was occupied. Namely, the defendant was reckless and shot multiple rounds at 107 Coronado. We would offer that summary, Your Honor. States won the plea papers, the 3914, and the trial court certification of rights.
No objections.
Received. Based on the evidence before the court finds the evidence sufficient to find the defendant guilty as charged in this indictment, and I so find. Now, I just need to inform you, Mr. Chacon, now once, if they do send you down to TDC, or when they do, at a certain point, since there is not going to be an appeal of the case, this judgment will become final. If at some point that we have to try a case with some of the co-defendants, how many co-defendants are there, Mr. Duke, to your knowledge?
I think there's 3 or 4, Judge.
Okay. In any one of those cases, either the state or any one of those defendants could request for you to come in and testify in the case as to what their involvement or your involvement was in the case. Do you understand?
Yes, sir.
Okay. And the only thing that would be necessary for you to do would be to tell the truth, whatever happened. If you had to testify, I'm not saying you would, and I don't know if anybody would. Most of the time, they don't subpoena the people that have already pled, but sometimes they do, and there's no way to know. So if you do get called back here, then I'll get Mr. Harris to advise you of whatever's going on, and you can talk to him again in regards to any testimony if you have to give any. Now, at this point, nobody has offered you anything in exchange for this, right? This guilty plea, and they've not requested your testimony.
No, sir.
Okay, very good. All right. So with that, was there anything else I should need to discuss with the defendant? Mr. Harris, Mr. Duke?
No, Your Honor.
Okay. Thank you. And then we are finished with that plea. The sentence will be pursuant to the plea agreement, 2 years to serve. Good luck to you, sir.
All right.
All right, let's talk to Mr. Casillas.
Buena, Your Honor. Casillas. Come down after morning.
Judge, this is Robert Harris.
Yes, Mr. Harris.
It says Zoom, welcome, and then it stops for about 2 minutes, and then it goes, I go back on the picture. It's done it about 35 times.
Oh my gosh.
Not
Well,
good.
but you were able to be involved in the plea though, completely, right?
Yeah, but it's got this on and off kind of situation. But yes, I followed everything very well, and everything's very correct. But something's wrong. It's not us. It's you guys.
I don't know. Well, I have no idea what's going on, but anyway, you are
Me
completely.
neither. I don't know how these things work. But it wasn't us, because we've had that series all day today. Never had that problem.
Well, hopefully it won't happen again. All right. Well, thank you, and you are excused. Have a good day. Okay, now let's proceed on Carlos Roberto Casillas. I believe Mr. Ivy is the attorney for Mr. Casillas, and Mr. Duke is going to represent the state on this case also.
Yes, sir.
All right. Is your true, this is cause 2022 0D02448. Is your true and correct name Carlos Roberto Casillas?
Yes, Your Honor.
And is your date of birth 10/6 of 1999?
Yes, Your Honor.
Okay. And you recognize your attorney there, Mr. Ben Ivy.
Yes, Your Honor.
And Mr. Ivy, you recognize your client, Mr. Casillas.
Yes, Your Honor.
And so then, Mr. Duke, this is a plea agreement, so if you would like to state the plea agreement on the record.
Yes, Your Honor. In exchange for the defendant's plea of guilty, the state of Texas is recommending as to count 1, evading arrest or detention with a vehicle, which is a 3rd-degree felony, 3 years TDCJ credit for all time served. As to counts 2 and 3, smuggling of a person for pecuniary benefit, the state of Texas will be dismissing those 2 counts with a plea to count 1.
All right. And is that your understanding of the plea agreement, Mr. Ivy?
Yes, Your Honor.
Is it also your understanding of the plea agreement, Mr. Casillas?
Yes, Your Honor.
Now, the court hasn't, now you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your plea and we could proceed to a trial on this matter at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your plea. You cannot appeal the case without my consent. You would be sent to the Texas Department of Corrections at their earliest convenience to serve out whatever remains of this sentence. Now, you do have, let me see, look here real quickly. You do have a considerable amount of time already accrued. It looks like around 227 days, something like that. So you'll be given credit for all of that time. You understand?
Yes, Your Honor.
So now, like I said, we have in front of us some documents marked State's Exhibit 1, the guilty plea and waiver forms in this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, Your Honor.
Did you read them before you signed them?
Yes, Your Honor.
Did you understand what you were reading and signing?
Yes, Your Honor.
Did your attorney further explain to you the meaning of the documents?
Yes, Your Honor.
Do you have any question about their meaning?
No, Your Honor.
So if there's never any question, let me briefly explain to you what they mean. Primarily 2 things. First, you're coming into court, telling me through a judicial confession, yes, Judge, I did commit count 1 of this indictment, the evading charge, with a vehicle. And secondly, you're telling me that you understand that you're giving up some valuable rights here today. The most important of those rights, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Yes, Your Honor.
Understanding that, how do you plead then to count number 1 of the indictment, guilty or not guilty?
Guilty.
Are you entering your plea of guilty freely and voluntarily?
Yes, Your Honor.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, Your Honor.
Anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, Your Honor.
Now you understand, I believe this is a felony of the 3rd degree. Is it enhanced or not? I don't.
No, Your Honor. It's a
Okay.
3rd-degree felony.
So it's just 2 years to 10 years to serve in prison, a fine not to exceed $10,000. And you understand I'll send you somewhere within those general guidelines.
Yes, Your Honor.
You are a U.S. citizen.
No, Your Honor.
Okay. What is then what is your status?
Resident.
Okay. Then you understand that a plea of guilty may result in deportation, exclusion from admission, or denial of naturalization under federal law. You
Yes.
understand?
Yes,
Now,
Your
I
Honor.
think you probably had time to consult with an immigration attorney, Mr. Ivy, or yourself, correct?
Yes, Your Honor.
Okay. So, now, how old are you?
23.
How far did you go in school?
1 semester in college.
So you can certainly read and write the English language.
Yes, Your Honor.
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
No.
Suffered any serious head injuries?
No.
Are you telling me you are mentally competent? You understand everything that's going on here today?
Yes, Your Honor.
And counsel, you've had time to go over the facts, circumstances of the case, legal aspects of the case, and had time to evaluate your client's mental status?
Yes, Your Honor.
Yes, Your Honor.
Okay, and based on all that, are you representing to me that you believe he is mentally competent to enter this plea?
Yes, Judge.
Then based on your representation, Mr. Ivy, your representation, Mr. Casillas, The court's observations of you in court, both here today and prior occasions, I find that you're competent to enter the plea. State may summarize the evidence.
Yes, Your Honor. Had the state of Texas proceeded to trial, the state of Texas would have proven beyond a reasonable doubt in count one that on or about the 13th day of June 2022 in the county of El Paso and state of Texas, Carlos Roberto Casillas did then and there, while using a vehicle, intentionally flee from Daniel Martinez, a person the defendant knew was a peace officer who was attempting lawfully to arrest or detain the defendant. We would offer that summary, Your Honor. States won the plea papers, the 3914, and the trial court certification of rights. And I'm not sure if the court has the dismissals as to counts 1 and 2.
You mean counts 2 and 3?
2 and 3. You're right, Judge.
I have not seen them yet, but they
I
may have.
will forward them to Michelle right now, Judge.
All right. So, any objection to the evidence?
No, Your Honor.
All right. Then based on the evidence before the court finds the evidence sufficient to find the defendant guilty in count number 1 of the indictment, and I so find. I noticed that there's also a federal hold here or something. And so I don't know, is he going to go to the federal penitentiary first and then to the state, or is he going to go to state and then federal, or have they worked that out?
I really don't know, Judge. Yeah, I'm not sure what the process would be.
All right. Well, if he goes to the federal penitentiary first, I will certainly, give him credit, for all of this, and so that it'll run concurrent too with the federal case. No problem in that, is there, Mr. Duke?
No, there's no problem with running
Okay.
this sentence concurrent with any
Federal sentence.
potential federal sentence.
All right. So I will do that. And give him credit, of course, for all the time that he has served here in the El Paso County Detention Facility. Now, are you married, sir?
No, Your Honor.
Do you have children?
No, Your Honor.
And did you have a job? Were you employed?
Yes, Your Honor.
What kind of work did you do?
I was a meat market manager in Food King.
And did you live with family, friends?
With family.
What?
With family.
Okay. Well, I will follow the sentence then, the recommendation, 3 years to serve. Like I said, it'll run concurrent with any federal case and give you credit for all the time that you've served, and good luck to you, sir.
Yes, Your Honor. Thank you.
Okay, thank you. The next case, I guess this would be the last case that Mr. Duke has to do today.
Yes.
And
And
that's
I've reviewed Mr. Cortez's case, Judge, so.
All right, so let's talk about Mr.
Or Shapiro.
Yes, Antoine Cortez Shapiro. Now, today, this is a bond hearing, I think.
Yes, Your Honor.
On, let's see, Mr. Caballero is representing him, correct?
Yes, Judge.
And okay. Now I don't know where his bond is on all the cases. Did I revoke bond on certain cases, and do you know what all the bonds are?
Let me look.
Yes,
And
Judge.
how long has he's been in jail? Let's see, on this one. Let me look here.
66 days.
66 days.
Yes.
Because he's been in and out of jail on several of these charges off and on, and because I've had numerous hearings on him over the years, dating back to about 2019. We've got engaging, burglaries, assaults, drugs. And now what is this new case? This was another drug case? 2939? No, what is the 2939? Oh, that's a theft with
Yes, Judge.
previous convictions.
Judge, the last case I see him picking up is an assault on a peace officer. And that was in
Yes.
November of 22.
He also has the theft with previous convictions in 2022 indictment 2939.
Well, it's not with previous, it's over 2,500, under 30,000, Judge.
Oh, 2,500 to 30,000.
And he's got an additional theft that he picked up on July 19th. It's the same level of theft.
All right.
Yes.
So Mr. Caballero, if you'd like to state to the court, what evidence do you want to proffer to the court about what his bond should be?
Yes, Judge. I believe he was out on PR bond and then was recently revoked back in November. So now his bonds were revoked. They were all reverted back to 50,000. So that's why his bond is currently at $217,800. He can't afford any of that money. He nor his family can. His mother should be in the waiting room, Judge. She's here, and I was going to have her talk on a few matters with regards to their life. With regards to Mr. Shapiro, Judge, his case was recently transferred over to me because of his mental health issues and concerns. He is getting mental health treatment in the jail. There's a 1622 diagnosis of PTSD. And that was, I think, from 2022 last year when he was diagnosed. But in addition to that, I was speaking to his mother. He also has been diagnosed and been treated at UMC for major depressive disorder, anxiety, depression, and a few others. He was getting mental health treatment off and on. I guess in the past couple of years, he was getting full mental health treatment up until around 19 years old. When I did talk to him, let me take a step back. I was looking at the PR bond that was given to him last year on the theft charge of 2022 0D0 2939. And on that one, I didn't see any mental health component. So I think that would be the big difference here, is that he hasn't been getting the mental health treatment that he deserves. And if he were to be released, we'd be linking him with Takumi so he can continue on and actually stay on the right track. With regards to the two theft of property charges, one regards a quad, the other one is regarding a motorcycle. I'm not sure if it's a dirt bike or something like that, but in both cases, he claims he says he bought him fair and he bought him outright. And there's messages back and forth that he gave to the previous attorney, which I need to request, that shows that there was a transaction that went through, and that they were working with the cops to try to get the quad back to the person, but they also didn't want to lose out on the $2,000 they had paid for it. There's, with regards to the assault on a peace officer, that's the most recent one. There's from what I read, because I didn't have access to Portal on that case, I requested it today, but I didn't see if I had it in the last hour. They from the indictment, it says that he kicked an officer on the leg or something like that. I don't know more about that, but there on that case, I do know that I guess the sheriff's office did like an internal affairs, went to go talk to my client in jail and asked them more about the incident, because I guess a taser was involved, and they tased my client and hurt his arm pretty badly, I believe, or his hand. And they even asked if he was willing to do a polygraph test, which I told them not to speak to them until I had a chance to, but I haven't had a chance to go more into detail into that. Right now, Judge, if he gets out, he'll be living with his mom at 12285 Greco Circle, El Paso, Texas, 79936. He lives there with his child, a 2-year-old that his mom has custody of and is taking care of right now. His mom works nights as she's a bar manager, and her hours had to be cut back because she's watching over his child. She also pays daycare $15 a week, not including the babysitting that she has to procure while she's at work on her night shift. If released, Mr. Cortez will be working at Mobile Mechanics. His brother works there and is securing a job for him on that, Your Honor. The family can afford around $200. They don't have much money, especially that they're caring for the child. There is a continuing, just so I can mention it now, Judge, one of the charges is a continuous violence against the family. The CW in that case, in the police report and all the information we have, has repeatedly stated she doesn't want to press charges and doesn't want to prosecute, but they went ahead and did it anyways and brought the charges.
All right. Okay, did you want to let the mother come in and so she let her tell me whatever, or have you brought up everything you wanted from her? Or do you want me to talk to hear from her?
Please,
I certainly don't want to deny you the opportunity to have her speak.
Thank you, Judge, please.
All right, well, have her let her enter so she can make her comments. And then I guess if Mr. Duke wants to cross-examine her, he could.
And I guess while we're waiting on that, Judge, I may just want to add that Mr. Cortez has never been. I was looking at his history. A lot of cases are dismissed, but I didn't see any pen trips that he's had. I didn't see any. Nor let me check if I even saw a felony conviction. I could be wrong, but I didn't think I saw anything like that either. Was she able to be brought in, Judge?
Well, I'm waiting.
Okay.
I thought, David, have you been able to get her?
What's,
Is
I
it
mean,
an iPhone or Jacob Reyes? I
yeah.
mean, which one is it? There's only two
What's
people in the waiting room, and it's iPhone and then Jacob Reyes.
it might be iPhone. I asked to title herself, but she probably doesn't know how to do that part. Let me.
I've let in
Miss-
iPhone, and maybe that's her.
Okay, Ms. Shapiro, are you there?
It's probably her.
Yes. All right, can you hear me, Ms. Shapiro? Unmute yourself, Ms. Shapiro, please. You're on mute.
There we go. I think that's it.
You did it, Ms. Shapiro. Thank you. I'm here with Judge Moody's is here along with the prosecutor Ray Duke and everyone in the court as well. Just wanted to bring you in just so you can explain to the court. You're strapped for money right now. Is that correct?
Yes, sir.
You watch Mr. Cortez Shapiro's son, his 2-year-old son.
Yes, sir.
His mother is not taking care of him. It's you that's currently watching him, right? Has custody of him.
Yes. Me
Yes.
and Cortez has custody of him.
Okay. And you pay her, most of your income goes to the rent, the utilities, and daycare. Is that correct?
Yes, and babysitting now.
And when Cortez was out of custody, he was working and helping pay for daycare and helping raise his son, correct?
Yes.
And if released, he would Cortez would live with you. Yes, at 12285 Greco Circle.
Yes. El Greco Circle. Yes.
And he'll follow up. And we talked about his mental health issues. Cortez will follow up with EHN on a permanent basis, correct?
Yes.
And that's something you want also, and you'll help him in doing that, right? If
Yes.
released?
Correct. Yes.
Okay. Thank you. Judge, do you have any questions for?
Do you know where the mother is, or is she able to contact her, or what happened?
She, when the baby was actually born, she used to stay with us and then she disappeared. And she would always like try to pop in and out. I don't know. I don't have any contact with her. Cortez had a little bit of contact with her, but the last time they said she needed to stay away because she always files like false accusations, because she likes to come, and if Cortez is not, how can I say, if he won't come and bring the baby out outside at 2:00 in the morning or different stuff, so she could see the baby, she would always have something crazy to say, and then she'll go call the police and say Cortez was fighting her. I didn't allow her back in the home after all that stuff was happening, and she never doesn't really like to talk to me. Why, I don't know. I've left messages for her, but I don't get any response.
Okay. Did you have any questions, Mr. Duke?
I have one question, Your Honor. Ma'am, is that Esmeralda Barraza? Is she the mother of your son's child?
Yes.
All right, thank you.
All right. Well, then now you basically have said, Mr. Caballero, that the only amount of bond they could probably post would be about a $2,000 cash surety bond. It'd be the maximum on all the charges put together. And then whatever else would have to be PR, correct?
Yes, Your Honor.
Okay, Mr. Duke, I need to hear your opinion as to what you think about that kind of a bond, or what you think the bonds ought to be, or
And
what's your
Judge,
thoughts?
I remember Mr. Cortez now. The last time that I dealt with Mr. Cortez was on the ag assault and burglary of a habitation with intent of another felony. And I remember this court let him out, and this is the one that he was represented by Mr. Pettis, and he wanted an ankle monitor, and I didn't think we had ankle monitors, if the court remembers. And come to find out, we do have ankle monitors. And
Yeah.
I remember the court contacting me again to say that the defendant was in violation of the bond, but I forgot what the violation was for at this point. And I know the court issued an arrest warrant for him for that violation. I'm looking at the PR bond revocations, and they all say basically the same thing, that he's not to commit additional violations by committing new crimes. And that's the only allegation I see on the PR bond motions, is that he was picking up new offenses. So he's got the continuous family violence. He has the 2 thefts. He has
Judge,
the
Laura just got kicked out.
oh wait.
Well, there she is. Oh, she's back.
Yeah, she's
Oh, I'm
calling.
sorry.
Okay, go ahead.
Are you back, Laura?
Can you mute
She's-
yourself,
she-
Mr. Pirro? Sorry, Ray.
Yes, I see myself.
Can you mute yourself?
mute me? Okay, hold
Yes.
on.
Thank you.
Do we have Laura back?
Yes, we're back.
We're
Okay,
back.
perfect. All right, so anyway, since
She's out.
January
She's out
30
again. I'm sorry, Mr. Duke. She's out again. Let me go check.
Okay,
Mine, yeah.
Judge, for what it's worth, I didn't need a record on this case.
Oh. All right. Well, from that point, if you don't need a record,
You want me
I
to
can let
proceed?
Mr. Duke continue on. Go
okay,
ahead.
I'll proceed then. So Judge, since January 30th, the defendant has picked up January 31st of 22. The defendant has picked up the following offenses: continuous violence. That was on January 31st. On May 12th, he picked up the first theft. On May 31st, he picked up a resisting arrest and a failed to ID, fugitive from justice. On July 19th, he picked up the other theft, state jail theft. July 22nd, he picked up 1 to 4 grams. November 22nd, he picked up a resisting arrest and an assault on the peace officer. In looking at his rap sheet, he's got a couple of convictions, but they're misdemeanors. There's nothing, I think he had 1 felony, but it was less than a gram and it was reduced to a 1244B. So I didn't see any felony convictions.
You said since what date? January what?
January 31st of last year, Judge.
So you listed 7 new arrests in basically 1 year.
Well, actually in about
Well,
10 months, if you want to.
oh, I was counting to today, but
Right, I'm counting from January 31st to November 22nd.
all right. So based on 7 new arrests while out on bond, what's your recommendation?
Judge, on the state jail thefts, I think currently, and correct me if I'm wrong, Andres, the bonds are 50,000 on those 2 state jails. I think that's probably a little high for a state jail. I would be okay with 10,000 surety on both. The resisting and the failed to ID, those can be PR if the court wishes to. The 1 to 4 grams of whatever the narcotic is, that's probably, I would say 10,000 for that one, Judge. And then the assault on the peace officer, I would go 20, and then whatever the resisting, whatever the court wishes.
I think the only ones I'm dealing with are the ones that
The
are
felonies,
the felonies.
Yeah.
So I'm not going to mess with any of the misdemeanors.
correct.
And
So
the problem is you're still probably somewhere.
oh, I'm way more than what the family is saying they can afford, Judge.
I don't know if you're,
I get that.
I mean, maybe 75 to 100 somewhere in there. I'm just trying to add up the numbers you came up, maybe 60 to 70,000.
That's probably about right, Judge.
And so I don't know if there's any, I don't like to just reduce bonds that they can't make anyway. I mean, I don't know.
Yeah,
what-
and Judge, I'm sorry, Mr. Shapiro appears to be probation eligible. The sticky part in this situation is that Ms. Shapiro currently gets assistance from housing, and there's certain charges, and I've read over some of the material, but I'm not 100% familiar to be able to advise at this time what charges may or may not affect someone's housing for regards Section 8. You know, and that's a big what good is if you're out, but then you're out on the streets. So
Yeah.
that's what I need to do more research. I did reach out to Mr. McLean's well, I don't know if it matters, wife from Trolla, and I am working with them as far as you know, what is permissible and what isn't, knowing what it can take if, you know, we can negotiate something. But in the meantime, I understand Ms. Shapiro and Mr. Shapiro's well, their need to take care of his son while the case gets resolved. It's a lot right now for them.
Well, you know, that's a lot of arrests for, I mean, maybe some of them aren't really strong cases, but that's still an awful lot of arrests while you're out on a PR bond, in my opinion.
Yes, Judge, and if I may add,
I'm not inclined to lower the bond very significantly.
if I just may, as regards to the charges that he has, those are very consistent with someone with mental health issues. I don't think Mr. Shapiro was properly treated. In speaking to his mom, I don't think he was getting the treatment they needed. They were on their way to get screened for EHN treatment, but he wasn't. This recent time, they weren't able to continue on with the medication. So I don't, just based on the PR bond that I saw on the theft, I don't think he was referred. I don't think he was given a fair chance to succeed as far as getting stabilized. But the resisting arrest, assault on a peace officer, those are very consistent and you know, things that we see with mental health.
Well, as of today, I'm going to deny the motions for the bonds, but I will let you and Mr. Duke maybe try to come up with a solution or something that might be acceptable to everyone. And if you can't, let me know, you know, but get back to me within about 2 weeks and see if you can get something worked out on all this.
Andres, can you reach out to Ingrid, because these aren't really my cases. I was just helping out Evelyn.
Sure. Yeah, I was going to ask you that. Ray,
Yeah, because Evelyn can't do them.
Yeah.
Right, because I think she represented the defendant at some point. So just reach out to Ingrid and maybe she
Sure.
can work something with you.
I sure will. Thank you very much.
All right. Thank you. Okay. Thank you, Mr. Dick. If you don't have any further cases, you're excused. And
Thank you, Your Honor.
same with you, Mr. Caballero, and the same. And then Ms. Shapiro, thank you very much. I appreciate your comments.
I'll call you, Ms. Shapiro. Bye-bye.
Thank you.
All right. Let's proceed with Mr. It would be Olguin.
Oh, that's mine, Judge. Oh, Dallas.
Yes.
Again, she's over here. She's right here, bro.
All right. Now we're hearing cause 2022 0D00849, the state of Texas versus that Odelis Guadalupe Olguin. Is that's your true and correct name, ma'am?
Yes, sir.
Okay. And your date of birth, 1/11 of 1997.
Yes, sir.
And you recognize your attorney there, Mr. Caballero? Okay. And Mr. Caballero, you recognize your client, Ms. Olguin?
Yes, I do, Your Honor.
All right. And then the state's attorney here is going to be Ms. Espinosa. So Ms. Espinosa, if you'd like to state the plea agreement here on the record.
Yes, Your Honor, the plea agreement to 2022 0D01936 and 00849 is to 10 TDCJ probated for 5 years. And I am dismissing 2022 0D05830.
So we got a 5 straight probation on which cases?
On the 1936 and 849, Judge.
And then you're going to dismiss, which one?
5830. And these are all 2022 cases.
All right. And is that your understanding of the plea agreement then, Mr. Caballero?
Yes, Judge, and I think we're gonna do a lesser on one of the charges. Let me pull it
That's
up,
correct,
please.
Judge. I apologize. On 1936, it is a first degree. We're doing the lesser included possession, dropping the manufacturer delivery. Sorry about that.
Okay. All right. And then is that your understanding of the plea agreement then, Mr. Caballero?
Yes, Judge.
And is it also your understanding of the plea agreement, Ms. Olguin?
Yes, sir.
Now you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your plea and we could proceed to a trial on these matters. But if I follow the plea agreement, it is final. You cannot withdraw your pleas. You cannot appeal these cases without my consent. You would begin serving these sentences immediately.
Yes,
You
sir.
understand? You understand it. Now, will this release her from jail? Does this cover all of her charges?
Your Honor, she has two misdemeanor charges that are also being dismissed today.
Okay, and so that will resolve everything, and so hopefully she'll get out of jail.
Yes, Judge.
If not today, maybe tomorrow or something, but whenever we can get all this processed. All right. Okay. Now, we have in front of us some documents marked States Exhibit 1, the guilty plea and waiver forms in the two cases that you're pleading on. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, sir.
Did you read them before you signed them?
Yes, sir.
Did you understand what you were reading and signing?
Yes, sir.
Did your attorney further explain to you the meaning of the documents?
Yes, sir.
Do you have any question about their meaning?
No, sir.
So if there's never any question, let me briefly explain to you what they mean. Primarily two things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit these offenses, or one of them, the lesser included offense, or was at least a party to those offenses as outlined under Texas law. And then secondly, you're telling me that you understand you're giving up some valuable rights here today. Most important of those rights, the right to a trial by jury, not only upon the issue of not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Yes, sir.
Understanding that, how do you plead then? Let's see. In cause 1936 to the lesser charge on the possession, and in cause 849, guilty or not guilty?
Guilty.
Okay, are you entering your pleas of guilty freely and voluntarily?
Yes, sir.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, sir.
Did anybody promise you anything, or persuade you in such a manner you felt you had to plead guilty, other than the plea agreement stated on the record in open court here this afternoon?
No, sir.
Now, you understand these are felonies of what degree, again, Ms. Espinosa, second, or
One is a second and the other is a third degree, Your Honor.
on the second degree, it's not less than 2 years, nor more than 10, second degree, not more than 20 years in prison, a fine not to exceed $10,000. But in lieu of that, I can place you on probation for any number of years, not less than 2, nor more than 10. On the other hand, if it's a third degree felony, it's not less than 2 years, nor more than 10 years in prison. Again, probation could be anywhere from 2 to 10 years. Again, another fine up to $10,000. You understand, I'll send you somewhere within those general guidelines.
Yes, sir.
You are a U.S. citizen,
Yes, sir.
and how old are you, ma'am?
26.
And how far did you go in school?
I dropped out in 9th grade.
You're able to read and write the English language, though, correct?
Yes, sir.
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
Yes, sir.
What kind?
Bipolar, anxiety, and depression.
Are you presently getting medications for those?
Yes, sir.
Are they helping you?
Yes, sir.
Are they helping you to such a degree that you believe that you're mentally competent and understand everything that's going on today?
Yes, sir.
And then, counsel, you've had time to go over the facts, circumstances of these cases, the legal aspects of the cases, and had time to evaluate your client's mental status.
Yes, Your Honor.
And based on all that, are you representing to me that you believe she is competent to enter the pleas?
Yes, Your Honor, based on my discussions and interactions with her.
All right. Then, based on your representation, Mr. Caballero, your representations, Ms. Holguin, and the court's observations of you, court both here today and prior occasions, find that you're competent to enter these pleas. The state may summarize the evidence.
Yes, Your Honor. Had the state proceeded to trial under 2022-0D0-1936, the state would have proven beyond a reasonable doubt each and every element in the lesser included offense of possession of a controlled substance, penalty group 1, more than 4 grams, less than 200 grams. And the state moves to introduce, or would have proven those facts beyond a reasonable doubt. The state moves to introduce state's exhibits 1 through 2, which are the plea papers and the 3914 disclosure form. And additionally, under 2022-0D00849, had the state proceeded to trial, the state would have proven beyond a reasonable doubt each and every element under the offense of possession of a controlled substance, penalty group 1, over 1 gram, less than 4 grams, as alleged in the indictment. The state moves to introduce state's exhibits 1 through 2 in that case, which are the plea papers and the 3914 disclosure form.
All right. Any objection to the evidence?
No, Your Honor.
Based on the evidence before the court finds the evidence sufficient to find the defendant guilty of the lesser included offense of possession in 1936 and find her guilty in cause 849. And I so find I'm ready to proceed upon the issue of punishment. Let's see, were you working before you were arrested?
No, sir. I was actually in the hospital.
Was that Aliviani?
No, I was in Del Sol Hospital.
What was the problem?
I got assaulted by the person that's already here in the annex. So I was at the hospital and I was getting therapy. Yeah.
Okay.
My mom told me not to go outside because the cops already knew that I was out of the hospital. But that's when I went outside and the sheriff passed by my house and he told me to come out. So that's when I came outside and I turned myself into the sheriff.
Okay. Now, were you supposed to go into some inpatient treatment at, where was that? Let me look at the name of that location. Alas Nuevas?
Yes, sir.
And you did not go in? Or
I went in for a couple hours and that's when I left.
yeah, I mean, I let you out so we could help you, and you didn't help. You didn't get help. You fled. And why?
I know, I apologize for that. I actually left because of the guy that I was with, the one that assaulted me. But I'm not with him anymore.
Okay, so
I have to
now where are you going to live when you get back? You going to live with
I'm
your
gonna
mother?
live with my mother and my grandfather. My grandma passed away, so I will be with my grandfather and my mother in Famous.
So you're going to live with your mother. And then are we going to make sure she gets some treatment for this drug addiction? Because I think the issue was meth before, right?
Well, yeah, she did have those charges, Judge. It was going to be mental health caseload, but we can also screen for OSAR or any kind of substance abuse. Of course, with probation, she'll have to be giving UAs and BAs.
Well, I really want her under some very intensive probation because I want to make sure that she gets some treatment. Because if she doesn't, then she'll just be back here and on a revocation to prison, and you wouldn't want to see that.
Yes, Judge. When she was released this last time and supposed to go to Alas Nuevas, she instead ended up going with that person, and that person ended up sending her to the hospital. That's why she was in the hospital. That person took a bat to her head and severely damaged her, and now she still has lasting, I guess, like a TBI issues. She learned a very, unintentionally, maybe a very bad lesson or valuable lesson.
All right. Well, I am sorry that happened to you. I really wish it would have been much better, as you can see, if you'd have just stayed at the treatment center. Maybe none of this would have ever happened.
You're right, sir.
And I did try to get her mom in, Judge. I know you like to speak to the family. I did send her a message, and I did try to get her into so she could speak to you and make the court feel more at ease, where that she's going to be released and not just to the street or back to bad habits. She is going to go with mom. Ever since the accident or the incident happened with that other person, mom has been taking care of her much more than she had. They've been much closer than they were ever before.
Right. Well, I hope that person has been charged.
They are. There's an open case. It's in the 409.
Good. All right. All right. Well, I will follow the recommendation. 5 years straight probation. They'll run concurrent, and good luck to you, ma'am.
Thank you, I appreciate it.
That's it for me, Judge. May I be excused?
Yes.
Thank you. Have a good day.
Let's see. Let's talk with Mr. Mendoza next.
Judge, and we're gonna need an interpreter. We're trying to get the interpreter to log in.
Okay. Do we not have an interpreter, or?
He's logging in, Judge.
Oh, good.
Hello? Okay, the address is from Stevens.
This one will also need to be arraigned, Judge.
All right. And I don't have any notes on the case, Ms. Espinosa, because I don't think we've ever even pre-trialed it. So when we do the plea, if you could be so kind as to just give me a very minimal rundown on the facts of the case.
Yes, Your Honor, this is on Rodriguez?
No, it's on Mendoza.
Mendoza, I apologize.
Juan Manuel Mendoza. And that's going to be Mr. Morales has that one.
Filling in for Mr. McLean on this one, Judge. He had to leave a
Wait.
little.
Oh, okay, because I saw Mr. McLean here, but he had to leave. Okay, now we have the interpreter here. Now, let's see, I've got to push a certain button so we get the interpretation right.
Correct, Judge.
Okay, why does somebody want to show me which one or tell me which one? Because I do see we have our excellent court interpreter here today.
And Rafael, just so you're aware, Intake has told me that they're going to dismiss, if he pleads to this case today, there is a P file tampering and possession that will be declined.
That's great. Thank you.
All right, we're now here in cause 2022-0D03828, the state of Texas versus Juan Manuel Mendoza. Is that your true and correct name, sir?
Sí. Juan Manuel Mendoza Cruz.
And your date of birth is 2/16/1970?
Sí.
Do you recognize your attorney or one of the attorneys representing you here, Mr. Morales? He's not dealt with him. He dealt with Mr. McLean. Okay. And so, all right. Then, Ms. Espinosa, if you would state the plea agreement on the record.
Yes, Your Honor, it's to 3 years deferred probation.
3 adult probation deferred on this case, and then you're going to dismiss or decline what now?
There is a tampering and possession of a controlled substance penalty group 1-1B under 1 gram that will be declined with today's plea.
Possession of controlled substance under 1 gram. So those will be, and so that should free him from jail, correct?
Judge, he's got immigration issues. He is not documented, so I believe that he'll be headed, there's an immigration hold on him, Judge.
Oh, okay, got it. All right, so now, Mr. Mendoza, we have in front of us some documents marked States Exhibit 1, the guilty plea and waiver forms in this case. They bear the signature of your attorney. Oh, wait, first of all, before I do that, was that also your understanding of the plea agreement that it would be 3 years deferred probation?
That is my understanding, Judge.
Okay, and is that your understanding also, Mr. Mendoza? Now, you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you can withdraw your plea. We could proceed to trial on this matter at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your plea. You cannot appeal the case. The case becomes final. You understand that?
Sí.
Now, we have in front of us some documents marked States Exhibit number 1, the guilty plea and waiver forms in this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Sí.
Did you have those documents translated and explained to you by your attorney?
Sí.
Did you understand what he was telling you?
Sí.
Do you have any question about the meaning of the documents?
Era para una audiencia hoy este día. Los papeles que yo firmé.
Yes. Did you have any other questions?
No, no.
All right. So what they mean primarily is 2 things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit this offense or I was involved in this offense as a party under the laws of the state of Texas. And secondly, you're telling me that you understand you're giving up some valuable rights here today. The most important of those rights, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Sí.
Now, you are not, let's see then. How do you plead then to this charge, guilty or not guilty?
Culpable.
Are you entering your plea of guilty freely and voluntarily?
Sí.
Did anybody force you or threaten you or coerce you in any way, make you plead guilty?
No, no.
Did anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in
No.
open court?
No, no.
Now, you are not a U.S. citizen, correct?
No.
So you understand a plea, in this case, apparently since they put a hold on you, will result in deportation, exclusion from admission, denial of naturalization under federal law. Did you understand that?
Sí.
All right. How old are you, sir?
Sí, voy a cumplir 52 en febrero. El 16 de febrero cumplo 52.
How far did you go in school?
La verdad no fui a la escuela, no.
Are you able to even read and write the Spanish language?
Sé leer poquito y es poquito nomás de los dos, no muy bien, la verdad.
But you understood everything your attorney was telling you.
Sí,
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
no,
Has suffered any serious head injuries?
no,
And are you telling me that you are mentally competent? You understand everything that's going on here this afternoon?
sí.
And counsel, you conferred with Mr. McLean in your office, and are you all representing to me that you believe he is mentally competent to enter this plea?
Judge, yes, our office believes that he is mentally competent to conduct the plea.
And now, one other thing, Mr. Mendoza, are you presently under any medications for mental health, mental illness issues?
No,
Okay. Well, then, based on your representations, the representations of your attorneys, the court finds, and the court's observations of you in court here today, I find that you're competent to enter the plea. The state may summarize the evidence.
Yes, Your Honor, had the state proceeded to trial in this case, the state would have proven beyond a reasonable doubt each and every element in the offense of possession of a controlled substance, penalty group 1, over 4 grams, under 200 grams, a second-degree felony, as alleged in the indictment. The state moves to introduce state's exhibits 1 through 2, which are the plea papers and the 3914 disclosure form.
No objection.
All right. Could you give me just again, I don't have hardly any facts here. If you could give me very briefly facts, because we never even pre-trialed this case.
Yes, Your Honor, this allegedly occurred February 25th of 2021. There was a traffic stop on a Nissan Altima. The defendant was the sole occupant. The traffic stop was on the basis that the defendant failed to signal lane change and also fictitious paper plates. As officers observed, the defendant dropped something in the center console. And he said that he had just purchased the vehicle, didn't know the plates were fake, asked for permission to search the vehicle, which he agreed to. And inside the pouch, which he had dropped in the center console, they found aggregate weight 6 grams of crack cocaine. The defendant took ownership. The labs came back at 4.36 grams of cocaine.
Has the defendant ever been to prison before?
No, Your Honor. He has no criminal convictions except for removal proceedings and inadmissibility, or I guess illegal reentry.
And I did forget, for the purposes of the arraignment, this case has come to us so quickly, he's never even been arraigned. For the purposes of arraignment, I did ask him if his true and correct name was Juan Manuel Mendoza, and he said it was, but it was Juan Manuel Mendoza, and then something else I forgot. Did you want us to add that other name to the indictment or not?
Judge, from our perspective, from the defense, do we absolutely need it, Judge, I guess?
No, we don't have to. But usually when I'm trying to on the purpose of arraignment is establish their true and correct name. And so if he wants that in the indictment, we can amend it and put it in, but it's up to him. Did you say it was Castro or what was it? I can't remember. Cruz. Did you want us to put that name in the indictment or not? you want to recommend to him one way or the other? Buckers?
I'll go ahead and recommend that we amend it, add the name just to be accurate, Judge.
Okay, so we can add that. And then, do you wish for me to read the indictment or do you waive the reading of the indictment, Mr. Morales?
We will waive the reading of the indictment, Judge.
And you initially enter your plea of not guilty to that, correct?
That is correct, Judge.
And now we're changing the plea to guilty. Now, and I do have to explain to you, Mr. Mendoza, you would have had up to 10 days after the arraignment, which is occurring today. You could have up to 10 days to further process the case, or we can go ahead and resolve the case completely today pursuant to this plea agreement. Did you want to wait the 10 days or do you want to give up those 10 days and just finalize the case today?
Culpable.
Okay, well, do you want to then give up those 10 days and proceed to the sentencing now, or do you want to come back and redo this in 10 more days?
No, pues.
Okay, so I'll take that as a waiver and we'll proceed then. Do you have family, or you married? You have children?
No. No tengo nadie aquí, nomás tengo una amiga nomás aquí en el.
Okay. And then apparently if you go back to Mexico, will you have a place to stay or something, family there? Or?
Sí.
Okay. All right. Well, I will follow the recommendation, 3 years deferred. But the only real condition of probation, if you are actually deported to Mexico, would be very simple, which is just don't re-enter the United States without the permission of the government of the United States. If you do enter the United States, you need to report to your probation officers. If the government of the United States allows you to come back in the country, then you would need to report to the probation department. You understand?
Sí.
Okay. All right. Well, I will follow the recommendation, 3 years probation deferred, and good luck to you, sir. Did we have any more that needed an interpreter? We have left. Does anybody know if we need an interpreter any further, or can I excuse the interpreter?
Judge,
We've got Mr. Contreras, we have Mr. King, we have Mr. McCoy, we have Mr. Rodriguez, and that's it. Any of them need an interpreter?
none of mine need an interpreter, Judge.
And I think they're all yours from here on out, correct?
I believe so.
Okay, well, thank you, ma'am. Okay, let's proceed next on Mr. Contreras.
Judge, I think we got Mr. King in front of us.
Oh. Okay. It's gonna do. Oh, I see two of them. One of them's in the one jail, one's in the other. Okay, well, is Mr. Contreras, is that you, sir? Yes,
Yes, sir.
okay, well, let's do that one. He's
Sure.
at the downtown facility?
Yes, sir.
Okay. This is cause 2022-0D02913. This is the bond hearing. And let me see what's going on here. On December 14th of this year, I received information that the defendant had stopped reporting. Starting November 8th of this year, and hadn't reported. So in December, I revoked his PR bond for not reporting and set that bond at $34,000. Now he's now been in jail. How many days?
3 weeks or so, Judge?
27.
27 days in jail. Did you turn yourself in or did you just get stopped on the street or what happened? Oh, you're gonna have to unmute you there.
I
Is
got
this
stopped.
on-
So were you like just in a car or on the street or what happened?
It was a misdemeanor charge, I believe.
Okay, so is there an actual misdemeanor charge on him also now?
I believe so, Judge.
What's that charge?
Let's see.
Uh,
Picked up on New Year's Day, looks like, new P file case. I believe, Evelyn, have you got the new charge? I just have that there was a new charge that occurred on New Year's Day, but I don't have the charge. Do you have it, Evelyn?
This is on Christopher Contreras, correct?
Ratio, I bet you can
It's
find.
interfering with public duties. And I believe that's the reason for the revocation of his previous PR bond.
Okay, now the original case was for impersonating a TABC agent. And he'd gone into an establishment here in El Paso and claimed that he was wanting to go in looking for underage drinkers. Security guard stopped him, thought he probably wasn't a TABC agent. They've got all this on video, and he wasn't. Apparently he'd done this before. He does have some criminal history. Got some noted here, both juvenile and adults. He's an electrician though, working at a warehouse. He's got a girlfriend and they're expecting a child. What was the bond previously? Was it a straight PR bond?
Judge, let me take a look.
Okay,
I have $3,000 PR bond. Judge, I guess that's what it was.
Let me check, Judge. Let's see what I find. Yes, Mr. Morales is right, 3,000 PR.
All right. Well, Mr. Morales, do you want to give me a synopsis of why you think he decided it wasn't important to report on his PR bond?
And Judge, your notes were correct in reference to the information about Mr. Contreras. The only thing that I would add to that warehouse and a child on the way was that he'd actually received his associate's degree from El Paso Community College. That's what my notes from having spoken to him a couple of months ago. The other thing that I guess it's maybe I'm getting a little old, Judge, but 27 still feels really young to me. And if the importance of being up to date with your bond conditions, what wasn't there before, nothing like 27 days in jail to kind of reemphasize that point. Not to suggest that there are any offenses that are not serious. All criminal offenses are. The interference with public duties, the new misdemeanor, and the original one, the impersonating a public servant or a law enforcement officer. I don't think that he's any kind of danger to the community, and I would just rather have him out and give him the opportunity to be with his family and with the baby that's either on the way or maybe even arrived by now, and get back to working and get back to his education. And hopefully that this is going to be the heavy reminder of the consequences that go along with not abiding by the court's order, Judge. I would just think that 27 days was enough to make that point, Judge.
Yeah, I think, and I also know you're still waiting on a UUMV case. Is that right? Is there something out there, a P file?
Yes, Your Honor, it's a unauthorized use of vehicle, that alleged date of occurrence is June 1st, 2022.
So we don't know if that's going to be indicted or not.
It's still a P file, correct, Judge?
The interference with a public servant, is that a misdemeanor or felony?
I think so. Misdemeanor,
Might
no?
be a misdemeanor, but Your Honor, I do have some of the facts in that new case.
Which one? The UAUMV or the interfering?
The interference.
Okay.
So once again, he's at Jaguars nightclub on January 1st of this year at 2:57 a.m. Police are actually detaining two other subjects, and they ask Mr. Contreras to walk away, to step away from the vehicle, to step away from their investigation of these two other individuals, to walk away from the police, from the patrol unit, I'm sorry, and he refuses. He continues to, I guess, get in the way, and so they eventually have to detain him. But it's of concern that it's again at the same nightclub, Judge, and so if
What time was it?
2:57 a.m.
Yeah, I mean, there's some more violations with additional. He doesn't seem to be paying much attention to his PR bond conditions. He's at a place where they're selling alcohol, or the alcohol being consumed. He's out past his curfew. He isn't bothering to even report to PR. Yes, did you want to say something, sir?
Yes. I wasn't drinking or nothing. I was Ubering.
Oh.
I was dropping off those two people that ended up getting arrested.
So you're like an Uber driver?
Yes, sir. The only reason why I was right there is because they left their wallet in the car. So I went over there. The officer told me to walk away. I was trying to give him their wallet, and then he ended up detaining me.
Hmm. You haven't made a rec yet on this case because you were waiting for the UUMV case to be processed. So you still don't have a rec on this case, right?
Correct, Judge. I still don't have one.
Given his history,
And Evelyn, I guess I did not catch the history this time. What was there significant criminal history? I guess I didn't hear that part.
no, there's not significant. There was an evading in 2015. There was some juvenile history with a weapon in 2008. Looks like it's probably still going to be a probation case. But it's looks like you might be having trouble following rules. I don't know if probation, it's maybe right back in trouble again.
Honor, if I can say, like, once pretty much on the 25th, my daughter was born.
When was your daughter born?
On the 25th
of December?
Of this month.
Oh, daughter born January 25th.
Yes, sir.
Just yesterday.
Yes, sir. And me not being there, pretty much put me down and stuff. But honestly, like, that's where all my mistakes was, when I was pretty much young and doing dumb stuff. But I'm ready to be a dad and just move on.
Your thoughts, Ms. Espinosa, if you have any?
Your Honor, I'll defer to the court.
I'd like to check with the PR bonding people. I want to see how he was doing up until he stopped reporting. There's certainly a lot of lack of maturity issues here. Hopefully, as you said, the birth of a child yesterday and missing that very, very important moment. This your first child?
Yes, sir, it is. I didn't report 2 months because I ended up getting 2 jobs. I just got honestly busy while the holidays and everything. And I'm gonna be honest, like I forgot. I really did forget.
Right. Well, I guess I'm going to reinstate. I don't want you to be spending money on a cash surety bond.
I appreciate it, Your Honor.
I want you to spend the money on your child. But I want you to report to PR bond. I want you to follow all those conditions. I don't want you at bars. I don't want you at, like, Jaguars, things like that. You obviously, are you living with the mother of the child?
Well, she's living with me, well, my mom at her house at the 3808 Truman Avenue.
You're all living together though?
Yes, sir, we are.
Okay. She already got the baby home yet?
She's supposed to go today or tomorrow.
Okay.
Judge, and I don't think, no, the curfew or no bars was on his previous PR bond.
Yeah, well,
And so we would just ask for that to be a condition.
I want those conditions on there. I don't want you going to bars. I want a curfew by 10 o'clock. So I don't want you out driving, you probably need to be home and help taking care of the baby anyway.
Yes, sir. Yeah, I'm not gonna do Uber no more. I'm just gonna do like an 8 to 5 job.
I don't want you out partying and things like that.
Yes, sir.
You understand?
Sir, yeah.
And because I really do want to see you I'd like to see you get home to it. You may not get to see the baby born, but it would be awful nice to, help carry the baby into the house.
I appreciate it, Your Honor.
Okay, so I'm gonna set the bond at 10,000 PR with those conditions. But I do want you to report once a week, at least for a month or so.
Yes, sir. Yes,
Okay.
sir.
And then if you're doing good, talk to Mr. Morales, and then maybe I can do it once, twice a month.
Yes, sir.
But I want to make sure you're taking it serious. You understand?
Yes, sir. Thank you, Judge.
Take this bonding seriously.
Yes, sir.
But I do want you to get to bond with your child. So it's a daughter?
Yes, sir.
Is she doing okay?
Yes, everything. I FaceTimed them, yeah, yesterday at the hospital. So
And is the mother doing okay?
yeah, she's doing okay.
How about grandma? Your
Oh,
mother?
she's ready for me to get out.
All right. Well, you got 3 women in your life you got to help.
Yes, sir. Absolutely.
So let's start focusing on them
Yes, sir.
instead of other things. All right.
Yes, sir. Thank you.
Okay. Thank you. Take care.
Thank you very much, Judge. Thank you.
All right. Let's next talk with. Yeah. If make sure if the clerk can get me that bond in a hurry, so I can sign it before I leave today.
Yes, Judge, I'm typing it now.
I want to see if they can get him out so he can maybe get
Okay.
maybe home. All right. Okay, let's talk about Mr. King now. I remember Mr. King because we've dealt with Mr. King before. I remember this case very well. And he had a pretty high bond, or he had a bond before, and I let him out back in last year, about the same time. Looks like January 27th, 2022. I had a bond hearing and he'd been in jail 94 days then. And I remember the case. And he's got kind of a rough criminal history. But it's been a while ago. I mean, it's not, it's over 10 years, I think. He's been in prison. He's been in prison a number of times. He had a lot of medical issues. And I was willing to take a chance and let him out. And I guess he was doing okay until
He's doing well for a while there, Judge, and
there's a new charge, a theft charge. That's why I had to revoke his bond. Because now where are we? What's the new charge?
so it was a theft charge, Judge, and I believe it was food. I believe that Mr. King was arrested for stealing food, and Judge, you pretty much got it spot on there. I will say that, and your bailiff, Mr. Pena, will have to corroborate this, but Mr. King even showed up to a couple of his hearings in person when he didn't have to. He definitely wanted to resolve this aggravated robbery. He was not. I guess maybe PR Bond might have some, I'm not sure what they have, but I know that Mr. King had appeared in person on multiple occasions there with the court, Judge, and he's been locked up for a bit, and you're absolutely right in terms of his age and his history and his current medical condition, Judge. He's got some serious medical issues that he's dealing with. Serious medical issues. I'm sure Miss Espinosa has some things as well, but we've gotten good information.
Yeah, hang on just one second. I gotta take
Sure.
care of one other thing before I get back to.
Double E, just to give you a heads up, my